Your employer is doing something right now that the law says they cannot do, and the odds are better than even that you have no idea, because nobody in that building has a financial interest in telling you. Economists estimate that American workers lose $50 billion a year to wage theft. To put that number in perspective, that is more money than is stolen in every robbery, every burglary, and every car theft in this country combined. And the vast majority of it is not committed by employers pulling off elaborate schemes. It's committed by employers doing ordinary things, requiring people to show up early without pay, docking salaried employees' paychecks, posting a handbook policy that has been illegal since the year Franklin Roosevelt was in his second term, and counting on you to never open the statute and read what it actually says. There is a federal complaint process. It costs you nothing to file, no attorney required. The moment you file, federal investigators go to work on your behalf. Most workers have never heard of it. I'm going to show you exactly how to use it tonight. My name is Paul Mercer. I practiced consumer protection law for 30 years, legal aid, tenant defense, wage disputes, and bad faith employment cases. Always on the people's side of the table. I'm retired now. I don't have clients. I don't have a practice to fill. And what I'm about to show you is something I used to charge $300 an hour to explain. Before I get into the specifics, let me be clear. What I'm sharing here is general legal information based on 30 years of practice, not legal advice for your specific situation. Employment law has significant state-level variation. If you have a complex case, a termination, or a high-dollar claim, consult a licensed attorney in your jurisdiction. I am not your lawyer. I'm the retired lawyer who will show you what the statutes actually say, so that when you do talk to a lawyer, or when you pick up the phone and call the federal agency yourself, you know what you're talking about. Here is what the research says is actually happening out there. A national survey conducted by the Institute for Women's Policy Research found that 48% of American workers report their employer either banned or discouraged them from discussing their pay with coworkers. Nearly half the working population is operating under a policy that has been illegal under federal law since 1935. 1935. 90 years old. And yet when I tell most workers that the policy in their employee handbook is illegal, they look at me like I'm the one who's confused. A separate study by the National Employment Law Project, NELP, surveyed nearly 4,000 workers in Chicago, Los Angeles, and New York City. In a single work week, 68% had experienced at least one pay-related violation. The average worker lost $51 out of weekly wages of $339. That is 15% of a paycheck, gone, in 1 week, because the worker didn't know what the statute said. If that's happening every week, that's over $2,600 a year from the same job, while the employer counts on you not knowing there's a law against it. And last fiscal year, workers filed 21,300 complaints against employers for labor law violations with one federal agency alone, the highest number in 8 years. 4 consecutive years of increase. That's not an accident. That's a wave of workers who found out what the law says. Here is what those enforcement numbers tell you about scale. The Department of Labor recovered approximately $1.5 billion in stolen wages over the last 3 years. Against $50 billion a year in estimated wage theft, the agency is recovering about 1%. The other 99%, employers kept it. That is not a system failing. That is a business model working exactly as designed, in direct proportion to how little you know. I'm not telling you your employer is evil. Most employment violations aren't malicious. They're business decisions that save money precisely because the worker doesn't read the regulation. The person in HR who handed you that handbook didn't write the law. They wrote the handbook, assuming you would never go read the law yourself. Tonight, you're going to read it. I'm going to walk you through 5 rights, the 5 I saw violated most consistently in 30 years of practice. I'll give you the exact statute each time, what it requires in plain English, and what you can do if it's been violated. At the end, I'll give you the filing procedure the employer is hoping you never use, and I'll tell you the one step most people skip, which is why their complaints go nowhere. Stay with me. The first right. The right to discuss your pay with your coworkers. The National Labor Relations Act, 29 United States Code, Section 157, commonly referred to as Section 7, gives every private sector employee in this country the legal right to discuss their wages, their hours, and their working conditions with coworkers. That right was enacted by Congress in 1935. It protects union workers. It protects non-union workers. It protects workers who have never thought about a union and never will. If your employer has a written policy, in the handbook, on a posted notice, in a company-wide email, that says you cannot discuss your pay, that policy is an unfair labor practice. Not a gray area, an unfair labor practice. The law has said so for 90 years. Here is what the violation looks like in daily life. A written policy that states compensation is confidential and may not be shared with other employees. A verbal instruction from a supervisor. We don't discuss salary here, that's a personal matter. A threat, spoken or implied. If I find out you're comparing paychecks with other people, your job is at risk. All of it, the written policy, the verbal instruction, the implied threat, falls within the reach of 29 U.S.C. Section 158A1. The employer can be ordered by the federal government to remove the policy from the handbook, post a written notice to all employees informing them of their rights, and pay full reinstatement with back wages, job search expenses, and compensation for adverse tax consequences to anyone who was disciplined or fired for exercising that right. Now, I want to be clear about who this covers. The NLRA protects private sector employees. If you work for a federal agency, a state or local government, or a public school system, the NLRA is not your framework. If you're classified as a supervisor or independent contractor, your coverage is different. And for the protection to fully apply, the conversation generally needs to involve more than one employee. The law protects workers acting together, what's called concerted activity. For the private sector employee told by a supervisor or a handbook that they cannot compare notes on pay, that instruction is against federal law. About 3 years before I retired, a client came to me, a mid-level accountant at a regional logistics company. She had compared notes with a colleague and discovered she was earning $14,000 less per year for the same role, same title, same years of experience. When she raised the question with her manager, she received a written warning for violating confidentiality policies related to compensation. She came to me thinking she had a discrimination claim, but the first thing I looked at was that warning itself. Because that warning, issued for the specific act of discussing salary, was an unfair labor practice independent of any discrimination question. We filed a charge with the National Labor Relations Board. The company was ordered to rescind the warning and expunge it from her record, post a workplace notice acknowledging employees' right to discuss compensation, and pay her the costs associated with the charge. The discrimination question was a longer fight. The retaliation settled quickly because the statute was unambiguous. They're not counting on winning, they're counting on you not filing. The second right, the right not to have your pay docked if you're a salaried employee. This one surprises almost everyone. Most salaried workers assume that being salaried means their paycheck can be adjusted at the employer's discretion. That's wrong. Under the Fair Labor Standards Act, 29 United States Code, Section 213, and the Department of Labor Regulation at 29 Code of Federal Regulations, Section 541.602, an employee can only be classified as exempt from overtime if the employer pays them a predetermined weekly salary not subject to reduction based on the quality or quantity of their work. If you are on salary, your employer cannot dock your paycheck because business was slow, because you left 2 hours early on a Thursday, or because you made an error on a project. Those deductions, what the regulation calls improper deductions, break what the law calls the salary basis test. If there is an actual practice of improper deductions, you may not have been legitimately exempt from overtime at all. The exemption required the employer to pay you on a genuine salary basis. If they were treating you like an hourly employee when it benefited them while calling you salaried to avoid paying overtime, the exemption may not have applied. You may be owed overtime for every hour over 40 you worked during that period, going back 2 or 3 years. The limit on this right? An isolated or inadvertent deduction that the employer promptly reimburses does not destroy the salary basis. The regulation requires an actual practice, A pattern of improper deductions, not a single corrected mistake. A pattern of deductions taken routinely, taken without reimbursement, or built into a written policy might. The third right. Overtime cannot be waived or signed away. Under the Fair Labor Standards Act, 29 U.S.C. Section 207A(1), every non-exempt employee must be paid 1.5 times their regular rate for every hour worked over 40 in a single work week. That right cannot be waived by contract, by company policy, or by you. It doesn't matter what it says in your offer letter. It doesn't matter if you signed an acknowledgement saying you understood you would sometimes work extra hours without additional pay. Congress decided in 1938 that overtime belongs to the worker and cannot be signed away. The agreement is void. Your employer cannot average your hours across 2 weeks. If you work 50 hours one week and 30 the next, you are owed overtime for 10 hours in week 1. The calculation is work week by work week. Some employers present 2-week averaging as a neutral scheduling practice. It is not neutral. It is a way to deny overtime that the law does not permit. When an employer violates the overtime rule, they owe back wages for the unpaid overtime plus an equal amount in liquidated damages, doubling the total recovery, unless they can demonstrate good faith. The statute of limitations is 2 years for a non-willful violation and 3 years if the employer knew about the requirement and violated it anyway. In July 2024, a federal court in the Western District of Pennsylvania ordered 15 nursing facilities and their owner to pay $35.8 million in back wages and liquidated damages to 6,000 workers. The court found that the employer had created and intentionally maintained a system to deny overtime. Not an oversight, not a misunderstanding, an intentional system. 6,000 workers, one employer, $35.8 million, and those workers assumed for years that the way their overtime was handled was just how it worked. The fourth right. Your tips belong to you. Under the Fair Labor Standards Act, 29 U.S.C. Section 203(m)(2)(b), an employer cannot keep any portion of an employee's tips. The manager cannot, the supervisor cannot, the owner cannot. A December 2024 opinion letter from the Department of Labor, FLSA 2024-02, reaffirmed that managers and supervisors are prohibited from participating in tip pools under any circumstances. It doesn't matter whether the employer uses a tip credit or pays the full minimum wage before tips. Not a single dollar of tips can go to management or ownership. If they have been, the recovery is all withheld tips plus an equal amount in liquidated damages plus attorney's fees. 7 states prohibit tip credits entirely: California, Oregon, Washington, Minnesota, Montana, Nevada, and Alaska. In those states, the employer must pay tipped workers the full state minimum wage before the first dollar in tips. Under federal law, employers can pay as little as $2.13 an hour if tips bring the total to the federal minimum wage. If you work in one of those 7 states and your employer has been using a tip credit calculation, that may be an additional violation. Check your state. The fifth right. Your employer cannot retaliate against you for reporting a workplace injury. Under the Occupational Safety and Health Act, Section 11C, 29 United States Code, Section 660C, it is illegal for an employer to fire, demote, transfer, cut the hours of, reduce the pay of, or otherwise take adverse action against an employee who reports a work injury or illness, raises a safety concern with a supervisor, refuses to perform work they reasonably believe is dangerous, or participates in an OSHA investigation. The law applies to most private sector employers. You do not need to have been correct about the safety concern. You need to have raised it in good faith based on a reasonable belief. The employer cannot retaliate for a good faith concern, even if the workplace turns out to be safe. The filing window under OSHA Section 11C is 30 days, not 60, not 90, 30 days from the date of the retaliatory action. If you were demoted or fired for reporting an injury, stop right now and count backward on a calendar. At day 31, the Section 11C protection is gone. It cannot be extended in most circumstances. That compressed window benefits employers who count on workers taking a few weeks to decide whether to act. If you are within that 30-day window, file with OSHA today. Contact information is in the description. Now let me be honest about what this video can and cannot do. The 5 rights I've described apply to most private sector workers under federal law. But the law has real limits. If your employer has fewer than 50 employees, the Family and Medical Leave Act does not apply to you. The FMLA covers employers with 50 or more employees within a 75-mile radius, and you must have worked at least 12 months and 1,250 hours in the past year to qualify. Some states have their own family leave laws with lower thresholds. Check your state. If a wage dispute has already become a lawsuit, this video is not enough. Get a licensed attorney. Many plaintiff-side employment attorneys work on contingency for FLSA wage claims, paid out of the recovery, not up front. If your situation involves discrimination based on race, gender, age, national origin, religion, or disability, you are in a different legal framework involving the Equal Employment Opportunity Commission, with its own filing windows, 180 days in most states, 300 days in states with their own anti-discrimination agencies. A licensed employment attorney is the right next step. On independent contractor status. If you believe you've been misclassified as a contractor when you should be an employee, you need a real attorney. The test varies by statute, varies by state, and the federal standard is actively being litigated. This video cannot answer it for your specific situation. About 8 years ago, a client came to me through a legal aid referral, a 43-year-old school administrator. Over the prior 2 years, he had been routinely required to arrive 20 minutes before his official shift for an operations briefing and to stay 30 minutes after to complete daily paperwork. 50 minutes every day, 5 days a week, not counted in his official hours. He was a non-exempt hourly employee, not being paid for that time. Under the Fair Labor Standards Act and the Portal-to-Portal Act, work that the employer suffers or permits, work the employer requires or is aware of and allows, is compensable time. Required pre-shift briefings and required post-shift administrative tasks are generally compensable. The employer cannot instruct you to clock out and then finish up. If they require it, they must pay for it. We filed a complaint with the Department of Labor Wage and Hour Division. The investigation found the pattern went back to his first year. The employer had been notified of compliance issues in a prior audit and had not corrected the practice, which meant the willful violation standard applied and the look-back period was 3 years. He recovered back wages plus an equal amount in liquidated damages. The math is usually far larger than people expect. 50 minutes a day, 5 days a week for 3 years is approximately 4 hours per week. At his hourly rate, the back wages alone exceeded $10,000. Doubled for the willful violation, over $20,000. From operations briefings and end-of-day paperwork that his manager told him was just part of the job. That is not a rounding error, that is a claim. And he had spent 2 years assuming it was just what the job required. Now here is exactly what you do. For violations of the NLRA, pay secrecy policies, retaliation for discussing wages, intimidation about salary discussions, the mechanism is an unfair labor practice charge filed with the National Labor Relations Board. The form is NLRB Form 508, Charge Against Employer. File electronically at nlrb.gov or call 1-844-762-6572. No filing fee. If the charge has merit, the NLRB pursues it on your behalf. The time limit on an NLRB charge is 6 months from the date of the violation, or from the most recent enforcement action against you in an ongoing situation. If your employer posted a pay secrecy policy years ago, the clock runs from the most recent incident in which it was applied against a specific person. For FLSA violations, overtime, off-the-clock work, tip violations, improper deductions from salaried employees, the mechanism is a complaint with the Department of Labor Wage and Hour Division. File at dol.gov/WHD or call 1-866-4-USWAGE. That is 1-866-4879-243. No attorney required, no filing fee. And retaliation for filing a DOL complaint is itself illegal under 29 U.S.C. Section 215A(3). The employer who fires you for filing is adding to the case against them. For OSHA retaliation following a workplace injury report, file directly at osha.gov or call 1-800-321-OSHA. Remember the 30-day window from the date of retaliation. Now the step most people skip. I mentioned it at the beginning. Here it is. Before you pick up the phone or open the browser to file, document the pattern in writing. Before. The federal complaint mechanism requires you to describe what happened, specifically, with dates, names, and amounts. A complaint that says, "My employer pays me late sometimes," goes nowhere. A complaint that says, "Between January 2025 and June 2025, I was required to begin work approximately 20 minutes before my scheduled shift and complete paperwork 30 minutes after, as instructed by my supervisor, and this time was not reflected in my time records or paychecks," goes somewhere. Write down the specific dates or date ranges, the approximate hours or dollar amounts, the names of supervisors who gave the instructions or witnessed the practice, and any supporting documents, pay stubs showing discrepancies, time records, the policy handbook with the illegal clause, emails. You don't need a complete case file. You need enough specificity that the investigator can verify the pattern independently. The difference between a complaint that gets investigated and one that gets closed in 60 days is that documentation. Before you file, consider whether you have coworkers in the same situation. The NLRB charge in particular is stronger when it involves more than one employee. Talk to your coworkers, which, as I've explained, is itself a protected activity under federal law. If you are in a state with stronger protections, use them. New York allows courts to award double liquidated damages for wage violations on top of the federal doubling provision. California requires employers to pay fired workers their final wages on the day of termination and imposes escalating penalties for each day of delay. Colorado, Illinois, Washington, and New York require employers to post salary ranges in job listings, a right that does not exist under federal law. The link in the description will take you to your state's Department of Labor or equivalent agency. Let me bring this back to the $50 billion number I started with. That number persists not because the law is on the employer's side. In every case I've described tonight, the pay secrecy policy, the improper deductions, the overtime denial, the tip skimming, the retaliation for injury reports, the law is clearly on the worker's side. That number persists because the employer is making a rational calculation that most workers will not know about the complaint process, will not pick up the phone, will not file the form. And that calculation has historically been correct. In 30 years of practice, I watched workers absorb years of wage theft because they assumed that if something were this clearly illegal, someone would have done something about it. Nobody steps in for you automatically. The system is set up for you to step in for yourself. And the employers who keep winning the bet are the ones whose workers don't know that's how the system works. The 21,300 NLRB charges filed last year, the highest in 8 years, is what happens when workers find out. Each one changed the calculus for the employer they filed against. The person who files doesn't need a law degree. They need to know which statute applies, which agency handles it, and what information to have ready. You now know all 3 of those things for the 5 most common violations I've described tonight. Let me give you the 3 things to walk away with. 1. If your employer has a written or verbal policy discouraging you from discussing pay with coworkers, photograph that policy or write down exactly what was said and by whom. Then file an NLRB charge at nlrb.gov or call 1-844-76-26-572, 6 months from the most recent incident. 2. If you are a non-exempt employee who has worked more than 40 hours in any week without receiving time and a half, or if you are a salaried employee whose paycheck has been docked for absences or performance, Call the DOL Wage and Hour Division at 1-866-4879-243. Document the pattern first: dates, amounts, supervisor names. 3. If you were fired, demoted, or had your hours cut after reporting a workplace injury, call OSHA today at 1-800-321-6742. Count the days since the retaliation. You may have very little time. Tell me in the comments what state you're in and whether you or someone you know has dealt with a wage issue. Overtime, tips, pay docking, pay secrecy, anything. I read every comment. If there's a pattern from a specific situation or state, that becomes the next video. Coming up next, I am going to show you the one clause in most employment offer letters that nearly every worker signs without reading, and that employers use to limit what you can recover if a violation occurs. It is usually 4 sentences long, buried on page 7, and it may already be in an agreement you signed. I'll show you exactly what it says, what it actually means, and whether it can be enforced against you when the moment comes. The fine print was written to confuse you. Now you can read it. See you next time.